Welcome to Patent Options Podcast, Securing Intellectual Property Strategies.
Hello and welcome to Patent Options Podcast, Securing Intellectual Property Strategies with Jamie Sheridan, Patent and Trademark Attorney of Sheridan Law, LLC. I'm your host, Abigail Vaca, and today's episode is Trademark 101, Protecting Your Brand and Standing Out in the Market. Thanks for joining me today.
Thank you, Abigail.
So for someone who's new to trademarks, how would you explain the basic concept of a trademark and why it's so crucial for a business protecting their brand?
Yeah, so trademarks are used to denote a source identifier of a product or service. So trademark rights arise through use. And so there isn't anything additional that one needs to do to have a trademark, but there are important reasons to take additional steps to have more rights in a trademark. Trademarks primarily are for, like I said, source identifier. They're to prevent consumer confusion. So one example that I like to give is walking down the aisle of your grocery store. Not that most people or lots of people drink Coca-Cola or Pepsi or something like that, but it seems to be a pretty easy example to give. If you're a Coke drinker, you might walk down the aisle and see Coca-Cola, Pepsi, and maybe some other brands and maybe a generic brand. And you look and, the less expensive brand might look pretty similar. And so you pick that one out, but then you realize after you drink it that it's not the source, it's not the quality, it's not what you like. You really like Coca-Cola. So Coca-Cola wants to keep its brand separate and easily identifiable and not susceptible to consumer confusion so that somebody who wants Coke buys Coke. And so the trademark rights help with that. So their colors and script and words, people have to respect those and make sure that they don't infringe by using a mark that is confusingly similar. So that gets into a lot of legal analysis and, how close one can be to another. And those are some of the things that we look at when we're dissecting and considering trademark rights.
So when a client comes to you with a new product or service, what's the first thing you look at when it comes to trademark strategy? And how do you guide them in the early stages of trademark protection?
Yeah, so with trademark strategy, I want to understand if they're using the mark already or if they intend to use the mark. Because under the US law, we can register marks that are being used. We can also submit an application to register a mark based on intent to use the mark. So I want to understand if they're using a word mark or a logo and a word, if there's color, if that's important or not, and what the goods and services are that they're using the mark with. And so once I understand all of those things, in my mind, I'm looking at the trademark spectrum of distinctiveness. If someone comes to me and says, well, I'd like to register the word apple, I'll say, well, what does the word apple connote? And if they say that, well, my product is, fruit and I have an orchard, then I'll say, well, if you're selling apples themselves, your mark would be generic and you would not have any rights in that. So maybe we should think about other marks and words that you could use that would be more distinctive. On the opposite end of the spectrum are marks that relate to that are more fanciful or arbitrary. So, if you went back to the 1970s, people were producing computers and they decided to name their computer company Apple. Well, at that time, the word Apple had no meaning and no connotation when it came to computers. And so that arbitrary mark ended up being very strong, for computers. Most clients pick things that are more towards the middle. And marks that are suggestive are registrable. If they're merely descriptive, they're not. It's a very fine line, and there are legal arguments to help put the mark on one side or the other. And, we explore those if it's an important mark that someone wants to protect.
So what key factors should a business consider when selecting a trademark to ensure it's unique, legally protectable, and stands out in the marketplace?
Breaking trademarks is difficult. Lots of companies go through a process, a branding process, and in that branding process, they may spend many, many hours and lots of resources surveying people and finding a mark that they like, that it has a positive connotation to it, and they think that it goes well with their product. When I work with them on that, I'm looking at with a trademark clearance search on marks that are in similar industries, similar goods, similar services, and how similar the marks are. I do a pre filing search using an electronic tool that provides an initial clearance report. And then I go through that report and then discuss that with a client on third party registrations and other uses that may be an impediment to registrability. And generally, that impediment is that the marks are too close to one another, that there could be arguable infringement. And there's factors that go into that, fame of marks and aspects like that. And then the other major issue that we have to look at is the descriptiveness of the mark. So if we look at that and it's too descriptive, then there may be impediments to registration as well. And then whether it needs to be rebranded or modified, or just start back from scratch.
So, before applying for a trademark, you always recommend conducting a search. Could you walk us through the trademark search process and explain why it's so important?
So a search is important. It's not required, but it's generally important because the process of filing for a trademark these days is 6 to 9 months before the USPTO will provide an initial feedback on a application that's been filed to register a trademark. Because of that long period of time, you could start off on a track of building rights and then ultimately have to rebrand. So pre-filing search is generally really quick. We're just looking at the word mark itself, or we have a tool we could also search logos and see what's close, again, in the same goods and services. And it's broader than one might think, but it's important, to do it that way and get relevant matches and look at those. Similar to patent searching and trademark searching is unless you use the right tools and you go about it the right way, you either can be susceptible to receiving little to no hits or matches, or receiving way too many and having to wade through those can be very difficult. So it's finding the right match of relevant marks that are being used out there and making a comparison to those. The other type of searching that can be very important is what a lot of trademark practitioners refer to as a full search. And that's a more extensive commercial search that, is going to involve a bit more cost and time, but that's very beneficial if someone's going to spend hundreds of thousands or millions of dollars in their branding or other activities. That's going to be very difficult to rebrand, in 6 months or a year if there's a third party infringement that's identified in a short period of time.
So, what are some of the common mistakes that businesses make when it comes to trademarks, and how can they avoid them earlier in the process?
So common mistakes include how the trademark's used, using it in a generic fashion, picking a trademark that is too descriptive, not branding with the correct descriptive words together with the trademark. So those are all things that we can look at as the trademark's being secured and as the use is occurring. Probably less often, there's innocent mistakes of using the R in the circle symbol to denote that it's registered. In the United States, that symbol cannot be used until you have a U.S. registration received from the U.S. Patent and Trademark Office. So that can be a mistake, but that one's easily remedied. Trademarks are somewhat flexible, and there's usually some period to correct the use of the trademark and maintain rights. But that's not always so. So it's important to have good advice as you're going forward and building those trademarks.
Okay, so let's say a business is ready to file for a trademark. What's involved in the actual application process? And how do you guide them through this stage? Like, what are those potential challenges they may face?
So, one of the key factors in filing a trademark application is correctly identifying who the owner of the application for registration is. That can be a hurdle that is not one of the areas that's easy to fix, especially in, in an application that's based on an intent to use the trademark. So, it's important to talk with me and figure out if your company is going to be the owner, what the name of your company is, where your company is formed, that it's the correct company. Some people have more than one company, and there may be related aspects to the different companies, but it's really the company that has ownership and is either actively using the mark or will be the company using the mark. So that's important. It's also important to correctly identify the goods and services. The U.S. Patent and Trademark Office has some flexibility, and it's growing less and less for various reasons on how you characterize your goods and services. But it's important that we characterize those in the right scope so that you get the right amount of protection and that you potentially don't overlap with other marks that you don't really care about, and maybe they don't really care about your use and your industry. So getting that right size for the goods and services, can be very, very important. And then, probably one of the other things to look at is for the mark that's in use or you're going to be using it, is making sure you get a specimen of use that correctly shows how you're using the mark today. And it has to be a bona fide use. If it's your website and you're fulfilling orders, that's generally great, and we can use that. But there's certain aspects, if it's a shopping cart, what the USPTO wants to see for your online presence. So I help clients all the time navigate through that. And then other times, help them with some suggestions about how they can better use their mark on their website or in other materials that they're using in connection with their customers.
So, after a trademark is registered, what steps do businesses need to take to maintain and protect their trademark? And how important is ongoing monitoring to safeguard their rights?
So it is trademark monitoring, and you do have a duty to police your own mark. The U.S. Patent and Trademark Office or the FBI or any other federal agency is not out there policing marks. So you, as the brand owner, need to take those affirmative steps. We have tools that allow us to do that in a timely and efficient manner so that there's not, significant cost as you're building up these trademark rights that could be worth and usually are worth much more than tangible assets of a business. So we look at those aspects of it. And a lot of times it's just putting third parties on notice that they can't use the same mark and then they'll rebrand. There's processes through the U.S. Patent and Trademark Office that are relatively straightforward and limited cost to be able to do the same thing. And then there's always federal court, which for my clients, not a litigator, we try to take steps to avoid litigation. But when we do need to litigate, I work with other lawyers that do a lot of work in that area. We try to do that in a very business-like fashion so that, again, there's efficiency in getting to a place where the marks are protected and the brands are respected by others in the industry and the consuming public.
So, trademark law is constantly evolving. Are there any recent trends or upcoming changes in trademark law that businesses should be aware of? And how should they adapt their strategies moving forward?
So the US Patent and Trademark Office provides a lot more options today than they did just a few years ago. There's also options that we now have that we didn't have a few years ago with international protection, such as through the Madrid Protocol. And, so a lot of aspects of trademark law are just implementing those strategies. The one area that's very important is e-commerce with things like Amazon and Facebook and other areas where your mark, instead of just being used in a limited geographic area, is really used all over the United States or even worldwide. And so looking at US trademark registration helps, because once you have a US registration, then we have options to work with Amazon or Facebook or others and their attorneys to quickly preserve your rights at a very low cost compared to third party arbitration or litigation. So, those being in a global world and with the tools that we have, trademark rights are very important to help identify your products and services compared to others out there who, may want to compete and sometimes not so fairly.
Great. Well, thank you again for joining me today. This has been wonderful.
Thank you, Abigail.
And thank you for joining us on Patent Options Podcast, Securing Intellectual Property Strategies with Jamie Sheridan. To connect with Jamie, visit www.sheridanlaw.com. And please like, subscribe, and leave a review on your favorite platform.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.